Okay, so our first trio is, and we don't have a full second trio yet, so feel free to jump in. Now we do. Okay, so the first three are Brian Wildenthal, Stanley Fish, and Heidi Hurd.
Well, my comment was kind of maybe going a little bit off on a tangent, but it seemed like that Bob Bennett's paper is a logical point to raise this, since you identified as someone who is not an originalist, and I'm kind of an ambivalent originalist myself, since I'm also kind of a card-carrying liberal and admirer of most of what the Warren Court does. So I'm not unsympathetic to what you're saying, that it's necessary to, if I had the quote right, that interpretation requires large-scale importation over time of contemporary values. I have some sympathy with that idea. You said we have to be realistic. This is the only way judicial review can proceed. My question is it seems like a standard critique of originalism typically involves two main moves. One, look at all the horrible, unacceptable results it would lead to, and secondly, there's no realistic way to amend the Constitution to bring the original meaning satisfactorily into line and up to date with modern needs and values. So I'm just curious, is it possible that the fact and significance and availability of constitutional amendment has been underplayed or ignored too much in accounts of the need for the living Constitution? And is it possible that the need for large-scale importation over time of contemporary values could and or should proceed by amendment as opposed to through judicial review, judicial interpretation? If not, why not? It kind of struck me that the whole saga of constitutional amendments, in some sense, doesn't get enough attention, either from proponents maybe or critics of originalism.
Stanley?
Yeah, I'm tempted to respond to the summing problem issue, but I hope Larry will take that up. I will say that I don't think there's any problem because it's not a question of individual intenders who are aggregated. Rather, I think it's a question of individuals who are acting in institutional roles. And that therefore, and as I've often said before, there is absolutely no psychology attached to intentionalism. Nothing about what's in people's minds. I couldn't care less. But I want to. My main reason for speaking was to ask Bob a question, whether he would accept not an emendation, but accept this perhaps as a conclusion of his fascinating and, as I have told him before, extremely well-presented and well-written paper. You spoke at the end about the necessity, I believe, or the inevitability of importing, the inevitability of the large-scale importation of contemporary concerns and judgments. And I want to ask if you would accept a distinction between the ways in which that importation occurs. Because it seems to me there are two ways that it might occur. It could occur as a consequence of an effort to determine intention, realizing that effort, because it's an empirical effort, and faces all of the obstacles that you detail in the middle pages of your paper. So that effort is going to be made differently by different people, and it will be, as several around this table have acknowledged, an effort that can in time be revised. Earlier attempts declared to be wrong. What that will mean is that what the historical record of interpretation will show is that there are changes in what the original meaning or the intention of the framers or the statute makers might have been, and that those efforts, of course, to revise our understanding of what the intention was will be always contemporary efforts. Now, that I want to distinguish from the idea of the living Constitution as a positive project. That is, as something you actively want to do, that you just want to go as quickly as possible to the concerns and needs society evidences at the present moment and see the extent to which the words, let's say, of the Constitution or a statute can be made to serve those concerns and needs. Now, it could be the case that these two motives, these two motivations of interpreters could produce the same history. But from my point of view, it wouldn't be the same history. It could be the same history in the details in the interpretive details, but in the one case you would have a constitutional interpretation that had grown contemporaneously as the result of a process, the process of attempting to discern intention, and in the other case you would have a living constitution as the result of a positive norm, the norm to, as quickly as possible, bring the Constitution's words to a point where they can be seen immediately to aid us. And I think those are two different things, and that nothing that this account is not meant to be in any way a challenge to your thesis, but a conclusion that I think I would want to reach after reading it.
So, Bob, I completely agree. Larry, I get that we can intend default rules of using sort of conventional meanings to settle failures of matching and meshing. And I get that we can know that we're going to work out means of, to achieve shared ends, so that in, some sense of matching and meshing failures, we can sort of think of them as sort of short term, right? So I get how you can square up the values we want to square up in those kinds of cases. But let me give you a set of cases where I'm unclear how you come out. One is where you just get instances of mistakes that pass each other like ships in the night. So I want to tax vegetables, and I think tomatoes are vegetables. They're not.
Oh.
You want to tax fruits. You want to tax fruits, and you think that a tomato is a vegetable. So we agree to tax vegetables, right? And now the question is, do we have anything that counts as a sort of shared intention? We settle on taxing, settle on taxing tomatoes, but for reasons that in no sense match, and in ways that suggest that neither of us are getting what we would get if we didn't harbor certain forms of mistake. Okay, second set of instances are instances in which we or legislators deliberately, effectively blanket over, paper over failures to achieve matching or meshing that are not failures just to work out salient means to shared ends. So 3 quick cases. An instance of true ambiguity, double meaning, right? I want to tax financial banks. You want to tax blood banks. No mistakes, but we can't agree. So we just agree to tax banks, and we shove the issue downstream, right? So there's the ambiguity problem. Now vagueness. Sorry, Stanley. I want to get rid of snowmobiles in the park. You want to get rid of automobiles in the park. We can't agree, so we say no vehicles in the park, right? Third instance. We don't agree on the nature of a particular moral kind. We're actually after a particular moral kind, but we just don't agree on what it is. So I think gender equality when I'm worrying about equal treatment, and you're thinking racial equality when you're thinking about equal treatment, and we can't agree, so we just guarantee people equal protection or equal treatment, right? How in all of those kinds of cases do you get matching and meshing, or a sort of meta solution to the failures of matching and meshing?
Let me first respond to Larry, but I'm going to really make Heidi's point. Larry did not address. By the way, in his response in the essays, there's a more elaborate discussion of how you might ascribe an intention to a group with the division of labor, and it's quite wonderful. I loved it and learned from it. But he didn't address the problem of ambiguity, and he doesn't recognize in the remarks, and I think even in the papers, that ambiguity can frequently be put into the document quite intentionally or unintentionally, but get in there, and there are lots of ambiguities in the United States Constitution. With regard to Brian's comment, I'd be delighted to have more constitutional amendment if that was possible, practical. But my point is that in the process of deciding cases, in the way they come to court, interpretation of the document plays a role, and that is going to inevitably bring in contemporary values. And that's going to happen whether it's just a fact of life, I think, as long as you have serious judicial review in process, and that's going to be whether you have more robust constitutional amendment or not. With regard to Stanley, I'd say at least in part the same point. My point is an observation about what's going to happen. I would certainly avoid your second model of a living constitution. I don't want those 9 judges out there thinking, oh gosh, what would be a good way to change the world today? I don't think they do that, at least not in any pure sense. They do a little of it, but they don't do that as sort of a central part of what they're doing, and I think that'd be quite awful. So I'd be perfectly delighted to subscribe to the observation that these contemporary values are imported into the process as a result of trying to adjudicate cases. By the way, until the last panel, we didn't talk about dispute resolution at all. Marbury against Madison didn't say, judges, go out and interpret the Constitution and decide some disputes if you feel like it. They said, you have to interpret they said, we have to interpret the Constitution as a result of this core function that we've got of resolving disputes. Over time, the Supreme Court has become much more of a lawgiver, conceives of itself that way, but I still think that the dispute resolution function constrains its process to in very important ways. Your turn.
I'm just going to address Heidi's question. So let me do ambiguity first. Ambiguity is pervasive in the Constitution, right? There are many, many words and phrases that contain ambiguities. So to take my favorite example of an easy to resolve ambiguity, the Constitution uses the word Senate, right? Well, there are lots of things that are senates, right? It could be about the Roman Senate and so on and so forth. But from the publicly available context of constitutional utterance, we know that the Senate that the Constitution refers to is this newly created institution that's part of the Congress of the United States. So some ambiguities can be resolved by adverting to the publicly available context of utterance. Not all ambiguities can be resolved this way. So at least in theory, I think probably also in practice, but you have to argue it out fully on the merits, it's possible that there are cases of what I call irreducible ambiguity in the Constitution. That is a case in which it just doesn't, there just isn't any answer to the question, what did they mean? And a special case of that is the case where, and Heidi gave several of these, there is disagreement, and we paper over the disagreement by using an ambiguity, the meaning of which is actually a disjunction, right? And we're kicking the can down the road, and we're saying the courts are going to have to in some way choose. Now, I think that in such cases, you're not going to get an answer to the question, which of these two meanings is the linguistic meaning of the utterance? There just is no such fact of the matter. You're going to have to deal with the ambiguity, right? And the way I say that the ambiguity has to be dealt with is contained in the paper I gave here last year, right? That's in terms of the interpretation-construction distinction. Irreducible ambiguities require a construction, and it has to proceed based on inputs other than just linguistic information. So the second sort of problem that Heidi talked about was the problem of mistakes and the tomato case. And I think as you were articulating the hypo, you sort of switched terms. So let me just deal with this general problem. So we've got a statute that regulates fruits, let's say. And tomatoes are a fruit, but some members of the legislative body are mistaken about that. So the first thing I would want to do is to make sure that we don't have an ambiguity here, right? So it's very possible that there are actually two different senses of the word fruit, right? That there are biological fruits, which include tomatoes, but then that there are grocery store fruits, which excludes tomatoes, and that both of these are senses of the term that are in usage. And obviously you'd want to get it right which sense was the relevant sense, and that might solve the problem. But suppose it doesn't solve the problem because some of the people think that they're talking about biological fruits, and other people think that they're talking about grocery fruits, right? Is there then some procedure? And I want to assume that these are both conventional semantic meanings, so we can't solve this problem in that way. That requires us then to be committed to the idea that there is some procedure as part of the overall plan, as part of the overall constitutional scheme for resolving things of this sort. Right? Can there be a shared intention with respect to that? Sure, there can be. For example, it could be the McGinnis-Rappaport original methods solution, that the way we resolve this problem is by looking to the methods for interpretation that existed at the time we enacted the statute. And there are a variety of less fancy solutions, like courts will just decide, right? So we can still have shared intentions, and therefore we could still have shared meaning. And that may seem like both of these answers may seem like they're giving up on the determinacy of originalism, but I've never thought that originalism provided determinate answers to all questions. And I agree with John Harrison that if that's what you expect out of originalism, you're going to be severely disappointed.
Right. Thank you. Well, our next trio is Larry Alexander, Steve Smith, and Don Drips.
Well, I'm going to continue on just on Heidi's point because I was going to raise it, and this gives me a chance to agree with Heidi and disagree with Stanley. I do think it's psychology. It's psychology when it's one person, whose meaning we're after, and I don't. I've been in faculty meetings where it becomes apparent that we've all agreed on a document, but the meaning of that document we are in total disagreement about, and so you've Heidi basically giving you examples where there's ambiguity. So the recourse to conventional semantic meaning isn't going to get you out of it, right? There are different semantic meanings. Different semantic meanings for fruit as well as for banks. So two aspects, Larry, that you have here. And I just want to, I'm not disagreeing necessarily. I just want to try to figure out. So one possibility here is that somebody intends. I intend to mean X by this word. But if that isn't shared by the other people who are the body that has the authority, I don't have authority by myself to make this meaning authoritative. If that meaning isn't shared, then my second level is to say, go to the conventional semantic meaning of this in case we're disagreeing. And assume that I don't know what the conventional semantic meaning is. It's like a black box there. And it's a very odd psychological state to be in. I say something, I mean something by it, but I want you to take it, in case other people don't mean the same thing by it, I want you to take it by looking inside this black box that I don't know about, which is the conventional meaning. And of course, which convention, the dictionary at the time I uttered this, the dictionary at the time you get the problem. So it's an odd mental state. The other point is that when you get the ambiguity, you say, well, it's for construction. One alternative to that is to say it's an ink blot, that's gibberish, right? You got two people who meant entirely different things. They were necessary for establishing the authority of the norm, but they mean entirely different things by the norm. So you have a string of symbols, but there is no common meaning that was given to those symbols by the persons who agreed to the symbols. So I would say that's gibberish, right? And so it's not something you can construct, right? It's no more than you're now beyond the Constitution or whatever document it is, and one answer is, well, it doesn't control. There's nothing there to control a dispute or anything else. It's we have ways of handling things where there's no authoritative document, and I would just say you failed to produce something meaningful in this case.
That's right.
Steve.
Okay. Well, actually, my comment and question is also directed mostly at Larry. I thought the paper was very intelligent paper. I actually think it's sort of possible. I think it's possible to agree with much of what both of you had said. But I thought Larry's comment was very interesting and helpful to me, and I liked it for a couple of reasons. I've sort of considered myself to be sort of with the intentionalists, with some misgivings, I suppose, occasionally. And one of them is that it seemed to me to be a bit of a problem, at least practically in a sense, for intentionalists if they are too willing to concede that gibberish happens in a whole range of cases, as Larry, I think, often seems to be very happy to concede that. Both of you, I think, agree that it sometimes happens, that there's something that looks like an act of communication or whatever, but it ends up not meaning anything. But if that happens regularly, and so forth, that gets to be a bit of a problem. And I think you've sort of helpfully shown how that's not going to happen, that doesn't need to be the pervasive problem that it might be on other versions of intentionalism. You also seem to me to give a fairly realistic account of what probably actually happens, in many of these sort of group type situations. And In addition, just in the assumption that the psalm says it's good for brethren to dwell together in peace, if you can make some move towards bringing intentionalists and textualists together, that seems like a good thing, although obviously you haven't succeeded in doing it fully. But in the interest of doing that, I want to offer this as a kind of friendly, not amendment, I hope, but addendum, and see if you'd agree with it, sort of in the interest of, I hope a small point, but would you also be willing, is it also true, would you acknowledge that the conventional semantic meanings that a speaker might intend to essentially, connect to are themselves the product of merely like generalizations about speakers and their intended meaning, so that even those are essentially intentional, semantic meanings, although of a somewhat, broader, different kind, coming from a different source. Would I be right in assuming that, or if I got something wrong here? So, because I think if I am, it's going to be even easier for people like me and maybe to sort of go along with your blending of these views. So. Sorry.
Hang there, Steve. Well done.
Yeah, well, this doesn't really relate very much to what Larry and Steve just said, but I didn't want to. It does relate to something Larry Klaus said earlier, which is a challenge to people who are critical of originalism to compare attitudes towards the Constitution to other kinds of legal documents like statutes and cases. And when I think of how we read Supreme Court cases and how the Supreme Court expects us to read them, it doesn't. It's not either intentionalism or original public meaning. I mean, it's the concurring opinion which controls. And the distinction between holding and dicta is not something which we would. That's not a way to find the intention of the people who wrote the case. And so I would just like to draw you both out on that. What strikes me as sort of a disconnect between how we expect certain kinds of legal texts to be read. And certainly I don't think the authors of the Supreme Court opinions are drafting them with the very expectation that subsequent justices hostile to the position they would hope to see achieved will be trying to find ways around the way the opinion is crafted.
Gosh, that's a nice set of problems that I haven't really thought much about. I guess my initial reaction is that, like constitutional interpretation being embedded in a dispute resolution process over time, so the treatment of judicial opinions is itself embedded in a dispute resolution process over time and subject to the kinds of conflicting pressures and approaches that you're suggesting. Let me say one thing in answer to Larry. I don't think the gibberish point can be carried quite as far as, or at least it's awkward to carry it quite as far as you're suggesting. I think there are ambiguities, what I would call ambiguities in the Constitution, lots of them, and they can have important consequences. Some will get to court, some won't get to court, but at least in some of the examples that come to my mind, should they get to court, for the court to say, well, we've got this piece of constitutional language, you've got this piece of constitutional language, you read the one, and it seems to lead to this result, you read the other and leads to a different result. An example, but it's only one of many, is whether presentment is required for constitutional amendments. Article 1 and Article 5 could be read very differently in answering that. Should that question get to court, it's unlikely to, but should it get to court, I don't see the courts as really having an option to say, well, I've got these words here and they seem to cut in different directions, and that means we won't decide it.
So let's see. On Don's question first, I think that there's two things going on here. One thing, it concerns what the the linguistic meaning or semantic content of a Supreme Court of a judicial opinion is. And on that question, I think the justices are likely to be originalists. That is, they think that, and now you have to fill in the account, but I think that in this case, their intention is going to be that the conventional semantic meanings of the words, as modified by context, are the linguistic meaning of their opinion. And then there's the question of what legal effect the opinion will be given. That's a more complex question. It depends on a practice of stare decisis. And that practice, I think, is very complicated in ways that Don has suggested. On Steve's point, the friendly amendment. I think that it doesn't really matter whether all public meaning originalists would endorse this idea that conventional semantic meanings are themselves the products of intended meaning. Agreement at that theoretical level is not necessary for convergence to occur. So that's the first answer to the question. Second answer of the question is sort of what I think. So what I think is that there is a complex process here. You don't get conventional semantic meanings going until you have lots of speakers' meanings, right? And the speakers' meanings are produced by intentions, and so the conventional semantic meanings are a product of that. But then there's a feedback, right? That the process of developing conventional semantic meanings itself is part of what enables the relevant intentions for speakers' meanings. So it's complex, and you have to describe the whole thing. But as I understand the basic thrust of your point, I am willing, me personally, to accept it as a friendly amendment. On Larry's points, the second of which was this gibberish point, right? So, Larry, I want to agree that there can be what you're describing as gibberish. That is a failure of communication, right? I just want to agree with that. That seems to me obviously right. But you articulate the point as if it's a question of construction or gibberish, right? And I just want to say that the way I use the term construction, that would be a false opposition. Construction is the process by which we give legal effect to the text. So if your determination is gibberish equals no legal effect, that is a construction. It's a particular kind of construction. I tend to think that there are going to be lots of cases where we might not want to adopt that rule of construction, and that rather than giving the text no legal effect, we ought to adopt what I term a mending, that is without the A, not an amending construction, a mending construction. That is the construction that does the least violence to the text. For example, you can easily imagine that a crucial part of a legal document, say the Constitution, involved this kind of problem, and that the constitutional scheme would just fail in that case. And then I think that the case for amending construction is absolutely compelling, and that's what, in fact, I think you would do if faced with those circumstances and you were a real-world judge. And finally, on your black box point, it is not an odd mental state. It's a mental state that we rely on, the second-order mental state that says that I intend for my words to be understood on the basis of the conventional semantic meaning of the language, right? And then I have first-order intention as well, right? That second-order intention is something that we rely upon all the time because we are frequently in communicative situations in which the common knowledge condition for conveying speakers' meaning is not met. That is, the information about your intentional state, you know, right, is not available to the person who's going to read your words. And so you intend for your words, and this is clear in the case of instructions to be interpreted according to the conventional semantic meanings. It's not a queer state or an odd state or a weird state. It's the kind of state that we get the kind of intention that we have all the time.
Very good. I'll just jump in, moderator's privilege, with a comment on Larry's comment about, in response to the other Larry, about ink blots. I mean, there's no accident that Bork's ink blot line was used in respect of an individual rights limitation on government power, I think. And apropos of what Larry was just saying about essential aspects of the Constitution, as to every provision that apportions power between institutions, you've got to give it a meaning, right? Think of the Canadian Constitution that has this list of purportedly exclusive national powers and a list of purportedly exclusive provincial powers, all on the false premise that laws are only about one thing. And of course, every second law it's about commerce and it's about manufacturing. They're each in the two different lists. You've got to give it an answer. You know, there's no option of saying, oh, well, that's an ink blot. Okay, the next trio is Mike Rappaport, John Harrison, and Maimon Schwarzschild.
So Bob, Brian asked you about constitutional amendments, whether you were sort of underplaying them, and I guess you said, well, I think it's inevitable that the court will bring in contemporary values. Well, I mean, there's a question there whether it's inevitable or not. I guess I think it's very much a product of our legal culture. But I'm hopeful, as you'll see in a minute why, that is not really so inevitable. Because I hope it doesn't take us too far afield, but I want to talk just a second about the amendment process, because I think it's so very central here. I mentioned this to someone in the break, but there's a sort of line, sometimes that no justice, no peace, right? I think you can actually capture a lot about originalism with two sort of similar lines: that no amendment process, no originalism. But there's also no originalism, no amendment process. No amendment process, no originalism, right? So if inevitably you're going to have a constitution that needs to be updated, right? It's simply a mistake to think that originalism has to stand for the idea that we want these 200-year-old values solely incorporated. And so one way or the other, it's going to be updated. It'll either be updated by judges or it'll be updated by an amendment process. And so if there's no amendment process, really forget about originalism. On the other hand, if you don't have originalism, you're not going to have an amendment process. And why is that? Well, I'll just try to make the point very briefly by reference to the Equal Rights Amendment. Right? It's a very odd thing that the Equal Rights Amendment did not pass. Right? On one level, these are values that modern day Americans fully endorse. Exactly what the values are, another question, but and that's part of the problem. So why does it not pass? Well, I would say two reasons, both of which have to do with non-originalism. On the one hand, the court starts deciding cases and protecting women under the Equal Protection Clause, so you don't need the Equal Rights Amendment. And secondly, people start to get worried about, well, what's this thing going to mean? What's a non-originalist court going to do with this? And suddenly, it doesn't get passed. But, so I think there's really a central part about originalism that really is interconnected with this amendment process. I think the big problems get started during the New Deal, when the New Deal doesn't proceed and get any amendments. They just change the legal culture by thinking that they can rewrite the Constitution. There had been some of that beforehand, but not very much. So anyway, it's a little bit of a sort of sidetrack. But I in the end, I think that part of what this sort of change in the legal culture and that the sort of political movement about originalism is about is trying to change those understandings so that judges will feel less free to be able to bring in contemporary values to the same extent that they do now, and thereby leaving more room for an amendment process to operate.
John Harrison.
I too wrote down the phrase the large-scale importation of contemporary values and the idea that it's inevitable. And my question is whether the argument that that is inevitable has anything to do with change over time, and hence, in a sense, has anything to do with originalism. So 3 ways of thinking about that. First, Congress in 1789 had a major debate over what we would call the unitary executive, and whether the president had to be able to remove executive officers. At a time when the ratification process wasn't even over yet, there were only 11 states that were actually in. Was it inevitable at that point? No change in semantic meaning since the ratification, because it was still underway. Was it inevitable at that point that there would be the large-scale importation of contemporary values? Is it inevitable today that there be the large-scale importation of contemporary values, if necessary, into interpreting the 25th Amendment, drafted during the 1960s, and I'm pretty sure it doesn't contain any sort of 60s-isms, so it doesn't use the word heavy, so you'd have to wonder whether they meant heavy man, look at the lights. If there's a question under the 25th Amendment, is that required? And if you had the kind of person who fears the large-scale importation of contemporary values the way some people do, could you eliminate that difficulty? I think your answer is no, but I want to find out. Could you eliminate that difficulty by saying the Constitution is going to be interpreted in light of its conventional semantic meanings, which are fixed by facts about linguistic usage, as of 2011? Same text, contemporary meanings, not necessarily contemporary values or anything else, just contemporary meanings. Would that make the importation of values go away? And if not, if the answer to all 3 is no, is it change over time that's really making a difference?
My question is sort of to Larry Solon, and to a large extent he addressed it, my question to Heidi. But I thought I'd press him a little bit on what the significance of moving from matching to meshing is. There is a nice sort of empirical ratification of the idea that he was that Larry was putting forth. There are some studies of how friends visiting New York City who lose track of each other. I guess they're people without mobile phones, so they're low-tech Larrys. When they lose track of each other, how they find each other, and it turns out that overwhelmingly, without any pre-existing plan, they meet at the information booth of Grand Central Station, and at noon, since the alternative is midnight, and most of them, unlike me, are not night people. The question, I guess, is whether with increasingly broad provisions of the Constitution, and I'm looking now not at differences in semantic meaning about words like Senate and fruit. That may be one of Empson's, 57 varieties of ambiguity. But at the most litigious and contentious provisions of the Constitution, due process, unreasonable search and seizure, privileges and immunities. I mean, I take it that Bob's objection to originalism in those contexts is that there's no matching, or your take on his objection is that there's no matching meaning there, and you suggest, well, a new metaphor of meshing. And my question is how the meshing metaphor is any help against Bob with those sorts of broad constitutional provisions.
Well, I'll leave this last question to you, but I'll try to respond to the two of you at once. Let me first plead innocent. When I say the importation of contemporary values, I don't mean exclusively or even predominantly values about the way our culture should be shaped, whether women should have equal rights or not. I am making a statement that the choices that have to be made are normative choices, and they may include choices like that, frequently do include choices like that, but they also include choices like how you interpret the Constitution, whether you're aggressive as a judge or minimalist as a judge, those are contemporary values too, and they are very much a part of the contemporary values that I am saying are inevitably a part of the mix. Now, is there a interplay between the possibility of amendment and the decisions that judges make? Yes, there is. I think it's undeniable. And might a judge take that into account in either being aggressive or not aggressive? Yes, but that would be the importation of contemporary values. They would be normative questions that the judges would join in on. I actually would like the two of you to tell me whether the conventional semantic meaning of the Equal Protection Clause leaves room for the decisions about sex discrimination that the judges made. The suggestion, if I understand it, is that that was beyond the pale. I've never heard that sort of assertion made about Yickwo against Hopkins, but at least I haven't read the history of the 14th Amendment in the way some of you all have, but my reading of it gives no suggestion that discrimination against foreign nationals was something that the framers of the 14th Amendment thought was forbidden by the Equal Protection Clause, but I've never seen a criticism of Yickwo against Hopkins. You can't find such a thing. Well, what about discrimination against women? Is that within the conventional semantic meaning of the Equal Protection Clause, or is it judicial activism? You got me.
So let me respond to Myman's question, and I think that it. Oh.
No, you get your turn.
All right. Let me respond to Myman's question, and it's about the broad provisions, right? And this relates to the question whether contemporary values are necessarily imported as well. So I just would want to reframe the question. I've been talking in response to Heidi, and that has led the conversation to problems of ambiguity, but there are also problems of vagueness, right? And so the general and abstract provisions of the Constitution, some of them may be vague, right? And if they are vague, then that means that the linguistic meaning leaves us with borderline cases. Some of these provisions may have big penumbras, right? And that means construction is required. Do we have to import contemporary values to fill in the penumbra? No, we don't have to. But that is a method of construction, right? Now, there are other methods of construction. For example, one could adopt Thayerianism or Paulsonism, right, and say that the vague provisions require us to defer to the political branches outside the core meaning. That's another option. Or we could adopt the Rappaport-McGinnis theory of meaning, only we would now be adapting it as a theory of construction, and we could say that construction ought to take place according to original methods, right? So those are some of the possibilities. Not all methods of construction require us to import values. I just want to say one thing about the privileges or immunities clause in particular, right, which is I think that that the whole history of Section 1 of the 14th Amendment has been confounded, complexified, and confused by the slaughterhouse cases, which I believe sort of went off on a clearly wrong track, and that contemporary understandings of the Equal Protection Clause, which I see as the protection of the laws clause, right, have been distorted by this initial failure with respect to the privileges or immunities clause, and likewise substantive due process is a side effect here. So give the originalist take on those provisions is far outside what I can do since we're over time already, right? But I think that you have to look at all three provisions, that once we get the original meanings of all three in place, that we have a much different picture than we have now, and that whatever role contemporary values might or might not have in the interpretation of Section 1, it's going to look a lot different after we get the original meaning straight, the core meaning straight, the things that are clearly outside straight. The construction zone is going to have a very different shape than does the construction zone of the judicially amended versions of those provisions. Are you going to take more questions?
I can't.
So in that case, I would like to express thanks to the organizers and for a terrific